afternoon, ma'am. This is Judge Davidson in the Kenosha County Circuit Court. Are you able to hear me?
I am, thank you.
Thank you.
Good afternoon.
Are the parties ready to proceed?
Yes.
Yes.
The court calls case number 24-CF-1494, State versus Crocker. May I have the appearances, please?
Rosa Delgado appears for the state.
And Marie Crocker appears in person with Attorney Benjamin Schwartz.
Good afternoon, all. This action is before the court for a sentencing after the defendant's plea. Defendant previously pled guilty to the following charges in the information. Count 1, first-degree child sexual assault with person under the age of 13, a Class B felony. Count 3, child sexual exploitation by video or other recording, a Class C felony. Count 4, exposing genitals or other intimate parts to a child, a Class I felony. Count 8, using a computer to facilitate a child sex crime, a Class C felony. Count 9, child enticement to sexual contact, a Class D felony. Count 10, second-degree sexual assault of a child, a Class C felony. And count 12, intimidating or threatening a victim, a Class G felony. The state dismissed but read in the following charges for purposes of sentencing. Count 2, possession of child pornography. Count 5, exposing a child to harmful material. Count 6, enticing a child to sexual contact. Count 7, exposing a child to harmful descriptions. And count 11, exposing a child to harmful material. The court ordered and has received a pre-sentence investigation from the Department of Corrections. Ms. Delgado, has the state reviewed the pre-sentence investigation?
Yes, I have.
Does it require any correction?
None by the state.
Mr. Schwartz, have you and your client reviewed the pre-sentence investigation?
Yes, Your Honor.
Does it require any corrections?
No.
Ms. Crocker,
Yes.
did you review the pre-sentence investigation?
Yes.
Does it require any corrections?
No.
Have the parties discussed or negotiated a proposed sentence subsequent to the entry of the plea, which the court will note for the record did not contemplate any proposed sentence? The court has simply confirmed that the parties have not subsequently discussed a proposed sentence.
That is correct, Your Honor. The parties have not subsequently discussed a proposed sentence. I believe the state is recommending prison, but will make no specific recommendation as to the length of initial confinement. They are free to argue the length of extended supervision up to the maximum time available for extended supervision, and are free to argue the conditions of extended supervision.
Ms. Delgado,
That's a correct statement.
have any victims requested restitution, Ms. Delgado?
So I can tell the court that the victim's mother, who is on the phone, I will just name her first name, Denise, she did indicate to our office that she wishes the court to consider imposing restitution for her son under Wisconsin statute 97320 sub 4 sub M, which pertains to cases such as this involving sexual assault of a child, where if the court finds that the crime was sexually motivated, restitution may be ordered and to require the defendant to pay an amount not to exceed $10,000, equal to the cost of necessary professional services relating to psychiatric and psychological care and treatment. It says that the $10,000 limit does not apply to any other restitution that might be requested, as we do normally in criminal cases. And so I would be requesting on her behalf, based on her request, that the court consider imposing $10,000 for victim JF for future counseling as requested by his mother.
Mr. Schwartz?
So, Your Honor, while the plea does contemplate a stipulation to restitution, I think it requires an actual amount. The statute that the state's citing indicates that the amount should be equal to the cost of necessary professional services relating to psychiatric and psychological care and treatment. So we haven't been provided with the actual number for that actual cost. If the victim's mother has an amount that they wish to submit, I'd certainly take a look at it, and if applicable, would probably stipulate to it per the plea agreement. But and if I could have one moment, because I believe there is also a case that prohibits Fuchs v. Handley, 173 Wisconsin 2nd 838 does prohibit requiring a convicted defendant to deposit money for possible future counseling costs. So I believe that statute does allow for the court to order actual costs incurred, but I don't believe it allows for sort of a amorphous and unknown amount or a blanket $10,000.
Thank you. Does the defendant have any pre-sentence confinement credit?
Yes, Your Honor, Ms. Crocker has 496 days sentence credit.
Is there any dispute from the state as to the amount of sentence credit?
No.
The court will also note for the record that in going forward, the court will be using the pseudonyms to refer to the defendants, and specifically referring to the defendants by the first names James, Zach, and Chris, just to avoid potential confusion with regards to the names or the identification of the victims going forward.
Can I just write that down real quick? You
And
said
the court will read
James,
it.
Zach,
James,
and Chris?
Zach, and Chris. Those names correspond to the victim's initials as pled in the information.
And there was a read-in victim, SDW, date of birth 11/25/07, who I will be mentioning, reference of counts 6 and 7. Do you want to select a name for SDW? Sam?
We'll use Sam. The court was reviewing its memory of the complaint to make sure it didn't select a name that was corresponding to the read-in victim's actual name. So we'll have Sam as well.
Okay.
With those preliminary matters out of the way, Ms. Delgado, is the state prepared to present its argument for sentencing?
The state is prepared. We would ask that James's mother speak first. She is on phone for the hearing.
Thank you. Ma'am, before we ask you to make your statement, the court is going to advise the members of the media in the gallery that this is the portion subject to the